All good to go.
Great, thank you. Good morning, everyone. This is day 6 and the final day of the Scoop Hill Community Wind Farm Inquiry. Now, today's session is the last of 3 hearing sessions and is focused on the conditions to be attached to consent in the event that Scottish ministers grant consent for the wind farm. So for the benefit of anybody joining us for the first time and any observers, my name is Christopher Warren. I'm a reporter from the Scottish Government's Planning and Environmental Appeals Division. I've been appointed by Scottish ministers to hold this inquiry. Can you all hear me clearly? All good so far? Good.
Yes, thank you.
Great. So as with previous sessions, the whole of the inquiry is being live streamed. That's on the DPEA webcast site, and a recording of each day's proceedings can also be viewed there. So the same disclaimer applies, that by participating today, you're consenting to the recording, storage and use of this material for webcasting training and for the keeping of records that are accessible by the public. Now, in terms of the format for today, I intend to principally structure the discussion around the most recent schedule of conditions, which I received late yesterday. So thank you for this. So I'll effectively be wanting to look at the schedule row by row, focusing on the matters where there's ongoing disagreement. You'll see from the agenda that I also want to consider whether there are any matters which are not addressed by the conditions in the schedule. So for those of you who are participating, please could you keep your cameras turned on if you're able to, but microphones muted unless you're speaking. So you can raise your virtual or physical hand when you wish to speak. And if you could please mute your microphones unless you're speaking, that would help with the sound quality as well as we go. Observers should keep microphones and cameras turned off, please. Now we have the whole day set aside again, but I think it's very unlikely that we'll need the full day for this session. I'm hopeful actually we might only need until lunchtime today. As with previous days, though, we'll take a break midway through the morning, and if we do need to break for lunch, we'll do so at a convenient point between 12:30 and 1 p.m. For an hour. Is everything clear so far? Seeing nods.
Perfectly clear, thank you.
Great. Okay, so I'd just like to now confirm who's taking part in this hearing session today. Come to the applicant first, Mr. Hardy.
So, myself, David Hardy, partner at CMS. You've known me from previous week. We've got Mr. Keith Campbell, who is going to be doing a considerable amount of the talking as well. And then the clients are on the line as well. So they're under Rebecca Elliott and Kirsty Kelshaw.
Great. Good morning to you all. Thank you. Mr. Armstrong, for council.
Good morning, sir. My name is Douglas Armstrong. I'm King's Counsel, member of the Faculty of Advocates and representing Dumfries and Galloway Council. I'm instructed by Sandy Fowler of Harper MacLeod, who is here today as well, and Gillian Bailey, planning consultant, will be doing most of the talking today in relation to the conditions.
Thank you. Good morning. And for the Ministry of Defence, Mr. Milne, good morning.
Good morning, sir. Douglas Milne, partner of Morton Fraser McRoberts, and I am joined today by Desmond Egan and James Houghton, both of the Defence Infrastructure Organisation, and really just to assist you, sir, today in respect of the limited number of conditions in which the MOD has an interest.
Thank you. Good morning to you all. Mr. Barker, good morning. You're muted, Mr. Barker.
Good morning, all. Thank you for having me again, and apologies in advance because I suspect my stripy shirt is looking scary to you because it certainly is scary on my screen. So apologies for poor shirt selection. I will be here to talk about any comments from either Visit Moffat or Moffat and District Community Council. And Mr. Warren, I'll do my best to identify in advance where those particular comments are coming from. Thank you.
Thank you, Mr. Barker. My screen's clearly not good enough because I can't even tell you've got a stripy shirt on, but thank you. And Mr. McClymont.
Good morning, Mr. Warren. I am not representing myself. I'm just here on behalf of God. So thank you very much.
Thank you, Mr. McClellan. Can I check, is there anybody else on the line who is expecting to participate and who I haven't given an opportunity to introduce themselves? Okay. So, assuming everyone's clear about what I've outlined still and doesn't have any questions before we commence, I'll launch straight into the schedule of conditions, if I may. So, I'm looking, as I say, at the very latest version. So that's helpful because it narrows down further the sort of areas of dispute. So I have nothing to ask you on condition 1. Please do say stop me though if you think actually there is something in a condition which I'm skipping over. Don't let me go past it without having the opportunity to speak. Condition 2 is agreed, I see. In terms of the point around whether I leave the time period as essentially to be confirmed for ministers is something I'll need to consider. I'll consider whether or not I think that's appropriate. If I was to put a 5 or 6 year period in that space, it's obviously still free for ministers to alter that as they see fit. They'll be aware of your respective positions from my report, so I'll consider how to approach that. See, condition 3 is now agreed. Condition 4 is now agreed. Condition 5 is agreed. Condition 6 is agreed. I've seen your email of yesterday afternoon, Mr. Milne, as well, and I'll come back to that in relation to the deemed planning permission and that slight amendment there. We're making good progress so far.
Sorry, sir.
Yeah, Mr. Milne. Sorry, Mr. Armstrong.
Just in relation to condition 6 on
Yes.
aviation lighting, that there still is an issue there as far as the council is concerned, and perhaps if I can leave it to Ms. Bailey to explain that one and put it in context.
Yeah, thank you. I just turned the page and seen all my scribbles all over this one actually. So thank you. Yeah. Ms. Bailey.
I mean, before then, I mean, there is perhaps just a minor point in relation to condition 5, and it's not something that the council's taking a point on, but I note that Nat's referred to developer, and the condition has gone back to, I think, the one that's in column 2, which is company.
Yes.
And on the definitions, the company is CWL, but the developer means the company, and its substitution therefore any other party who at the time has the benefit of this section 36 consent. I mean, it's not an issue. I just thought it might have been easier for the developer or the company if they had the that definition rather than the one that's suggested by Nats rather than the one that they're suggesting. But I just make that as a minor point. It's not an issue we're taking, but we are in relation to condition 6 have an issue. And if I pass over to
I think
Ms.
that's
Bailey
helpful,
on that.
Mr. Armstrong. It should say developer, I think.
It should say developer. Is that Mr. Hardy?
Yeah.
Mr. Milne, are you content with that as well? Oh, sorry, this is Nat's point anyway, isn't it? No, apologies. No, that's fine.
I thought that might be the case. Anyway, on condition 6, if I can pass over to Ms.
Thank
Bailey.
you.
Good morning, thank you. So yes, in terms of condition number 6, I think the remaining point for the council is that notwithstanding that there is a lighting scheme that has been agreed between the applicant and between the CA and MOD, the council has obviously got notable concerns in terms of the landscape and visual impacts of the scheme. And going back to the assessment that was undertaken by the council's landscape officer, she had recommended as part of any conditions that come forward that some further landscape mitigation in terms of what she described as shielding of lights could be undertaken. Now, I have checked this with her just to confirm my understanding of what she meant by that. And it's perhaps useful to just look at the most recent Nature Scots guidance, which sets out the different types of mitigation, and that's document CD 1731. And in that, on its page number, on the PDF, it's page number 9, it's paragraph number 40. It sets out 3 different types of mitigation. I'll just give you a minute just to make sure you've got that in front of you.
Yeah, thank you.
Can I just raise one technical matter, and that's Mr. Campbell, I think, has been thrown out of the meeting. It's just a message. I don't know what he's done wrong, but he, oh, here we go. He's come back in.
I do apologise. I was suddenly evicted.
Yeah, I used the word thrown out, Mr. Campbell. There you go, evicted.
Well, yeah.
Not sure what happened there, but you're back.
Back
So
in.
yeah,
Thanks for back.
shout again if we spot anybody that's disappeared inadvertently. Thank you. So it's 1731, wasn't it, Ms. Bailey?
1731, yes, that's the 2024 Nature Scott guidance on aviation lighting. And
Yeah.
paragraph 40, hang on, I've just lost that on my screen here. And it says the current suite of mitigation includes for 3 different types. So you've got automatic dimming, you've got vertical directional intensity, and you've got a reduced lighting scheme. Now, my understanding of the scheme that has been agreed between the applicant and with the CA and MOD is that automatic dimming is included and a reduced lighting scheme is included, but it doesn't include for the vertical directional intensity. As I say, I had checked this with the council's landscape officer to confirm what she meant by her references to shielding of lighting, and she has confirmed to me that she did mean the second of those options for vertical directional intensity. So the council's preference would certainly be that further reduced lighting aviation scheme would be submitted for approval by obviously the CA and MOD in relation to the technical safety requirements, but also with input from the council in terms of seeing whether all 3 of those aspects could be accommodated.
Thanks, Ms. Bailey. My understanding from Dr. Lumsden was that essentially the sort of vertical directional intensity was a characteristic of the LED light rather than a mitigation point in its own right. But I might be wrong on that. Mr. Hardy or Mr. Campbell, could you assist, please?
Yeah, our understanding is that, according with yours, sir, that is included as an aspect of the lighting. That said, our client is happy to make an addition to that condition to provide expressly that that mitigation will form part of the aviation lighting scheme.
So there would be specific reference to vertical
to
directional intensity.
Yeah.
I appreciate, Ms. Bailey or Mr. Armstrong, you haven't seen the wording of that aspect, but assuming that was done to your satisfaction, would that address your concern over the condition?
Yes, in principle, and subject to seeing any detailed wording, that would certainly address it. There were no other aspects of the condition that were of concern to the council.
The sort of general point, but picking up on that, I mean, I'm sure we can work with the council in relation to some wording, Ms. Bailey. So I don't know whether if we were given time to come up with a, you know, I'm sure there'll be other tweaks as well, but to come up with a final schedule, if that was acceptable to you. So I think that'd be a good thing to do.
I think so, yeah. I was going to say this towards the end because I think it's likely that there'll be other aspects which we talk about today,
exactly,
which will change things. So rather than me basing my conclusions and recommendations on scribbles all over 50 pages of colourful printing, I think that bringing it together would be very helpful.
Yeah.
I think, sir, if I may say as well, I suggest that by the time we get to the end of that process, there might also be some reordering of conditions just to make sure that it's in a sensible order as well. I think it generally is, but by the time you've considered any additional conditions and where those might be slotted in, it might be that there's some renumbering required.
I'm That's fine by me. As long as I'm clear that everything is still there that we've discussed and there's nothing disappearing by surprise, I'm pretty comfortable with that kind of thing. Okay. Can I just ask about on the conditioning column, or call it column 4 if we're including the condition number, in part 3 of condition 6, where it says this is in relation to the ADLS. So as soon as it becomes reasonably practicable. So I've got 2 questions about ADLS. My understanding is that ministers have previously rejected conditions relating to ADLS on the basis that there's no certainty over whether or not it can be implemented. So I've got a question there around, is there a precedent in terms of ADLS being included in conditions to date in Scotland? And then, well, I'll pause there. So that's the bigger of the 2 questions. So does anybody know if they've been used elsewhere?
So the answer is that the concern that you raised was the case of mine. That was the Narracon decision, Narracon decision, which I think you're referring to. Of course, the difference there is, or the difference with this scheme is that in terms of acceptability of the existing lighting scheme, because in that case, the existing lighting scheme, there was a question about whether that was acceptable on the Isle of Arran NSA. So it is relevant, but there are other decisions which have used and have passed the test. And the one that we're going to suggest, I think, if there is concern, is the one from the Lethans, the recent Lethans decision, which is before you, and that is what we're proposing. So there is precedent. It's more modern, and we think that provides the comfort that you need.
Yeah, that's helpful.
Lethans, the Lethans extension, I should say. It's not Lethans.
Yeah. In terms of that part 3, where it says capable of being deployed at a known and reasonably justifiable cost, it was just a question about. I mean, I don't take issue with that as a statement. It's in terms of the kind of circular 498 tests, in terms of is that sufficiently precise to say reasonably justifiable cost. Might be reasonably justifiable to ministers, but not to the operator, for example. So I'm just interested in your thoughts on that. So I'll come to you, Mr. Hardy, first, and then anybody else who has a view on that is welcome to share that with me.
It's tricky, isn't it? Because you're trying to cater for technology, which we kind of all know is out there. It's working in other countries. We know that it's but it's subject to CAA approval and those other things. You're not expecting there to be a massive tariff on it or something like that. And I think it was just trying to guard against that. The Lethans wording is slightly different here, and I think it removes that particular issue. I think certainty of reasonably justifiable cost, almost like you need an arbitrator for that, don't you? Or reason. I mean, reasonable is a term which is understood, which is known to the law. I think that even if you took out justifiable, that might help. But I think the Lethans extension condition, and I think we've got the wording. Let me just have a look to make sure whether the Lethans wording has got that. No, that actually does have, the Lethans wording does have that provision in. So as soon as it becomes, this is the Lethans wording, as soon as it becomes reasonably practicable, and then it has got that wording in.
Okay.
I don't know what others think, really. It has been passed. Other people have thought that's okay. I can see a concern about a term. I think making it slightly more precise would be to remove the word justifiable.
Ms. Bailey, do you have any thoughts on that?
Sorry, could I just clarify with Mr. Hardy when you say so for it to say capable of being deployed at a known and reasonable cost?
Reasonable, yeah.
Yeah, I mean, I understand the point being made, and I think it's a very difficult point to reach a judgment as in terms of what is reasonable as well as justifiable.
The reason I said reasonable is, and I said is just because that has a degree of objectivity. It seems to me. So it's wording, isn't it? Which the legal system knows. Justifiable seems to me to introduce more about, commercial profit margins and so on. You could take a view that something is reasonable objectively. That's expensive. Well, that's just a cost that the developer has to bear. Whereas justifiable feels to me as though that introduces an extra degree of potential commercial justification, which might be problematic. I don't think it solves the problem. I just think it makes it a bit better.
Yeah, I mean, I think I'd suggest that you'd then be getting into the circumstance that, given that, obviously Scottish
Details, including a timetable for their implementation of the revised mitigation measures, are to be submitted by the company for the written approval of the planning authority in consultation with the CAA, Glasgow Prestwick Airport, and the MOD. That was in that case.
Yeah. I mean, I guess my concern from a perspective as a planning practitioner would be that it's not necessarily sufficiently precise in that way, or give sufficient comfort that it would come forward. But I do appreciate, and I think this isn't actually one of the deemed planning permission conditions anyway. It's a Section 36 condition,
correct,
so it's not necessarily subject to those same
exactly those tests. Exactly. Yeah. I think that's an important point.
Yeah, I think, as I say, I think in planning terms you would have some difficulty with it, but I think I would just flag up that if you keep the wording in as it is, you may well get to some debate at the point that the scheme is submitted between the different parties that are involved in deciding whether it's approved or not.
Should we take that away then? So I was going to say, that's one of the things we can discuss, even if we come down at the end of the day, say, well, look, the Lethens, that is a condition which has been been approved, and the caveat might be entered by the council in notes or something like that. But that may be where we get to.
That sounds reasonable. Yeah, as a way forward. So I'm alert to the issue, and I can see it's an imperfect situation, but it's one of those situations which it's going to be difficult to entirely resolve. But yeah, that's fine by me. I'll see what you can devise.
Yeah.
Thank you. Okay, I don't have anything else on condition 6, section 36, condition 6.
Sir, on behalf of the MOD, if I could just mention, of course, the MOD would want to see any revised scheme, just with reference to the discussion about shielding. I can't imagine that would present a difficulty, and just for the sake of full information, what the MOD's lighting requirement is that all perimeter turbines are fitted with lights that emit either 25 CD visible light or infrared light, in accordance with MOD obstruction lighting guidance.
Okay. Thanks, Mr. Milne. Yeah, I will make sure that you're privy to the any alterations to it that are proposed.
Thank you.
Okay, so moving on. Condition 7 is now agreed. I don't have any questions on that. Then we're into the deemed planning permission conditions. Over the page, onto page 8 of the schedule. Now, so Yeah, so that's fine. So I can see that condition one's agreed as not being necessary, subject to that Annex 1 description. In terms of that Annex 1 description, obviously there's been under the further written submissions with matter 5, the western access route was amended, and that would need to be obviously captured. I'm assuming as part of that description of development there in Annex 1, that would be the most appropriate place to accommodate that. Are there any other changes beyond what's described in the additional information that I need to be aware of?
I don't think so, sir. I think it was just the exclusion of that section of access track, which was agreed by the applicant in the written submission.
I think the only other point that we'd noted was in terms of the outline habitat management enhancement plan, which was provided in October 2024. So that obviously doesn't form part of the additional information which was submitted with the application.
Okay, but in terms of, we have a separate condition in relation to the enhancement plan, don't we? Would that get addressed sufficiently later? Perhaps we can consider that in that context when we get to it.
I think that would be our position. That is separately conditioned with a requirement to submit a subsequent detailed plan based on that October outline plan.
I'll move us on to condition 2. I've got a tick against. That looks agreed. Yeah. Condition 3. Agreed. Okay, then condition 4, the micrositing point. So if I can just in a nutshell summarise the positions. So the applicant is seeking a 100-metre micrositing allowance. Council considers that to be excessive and proposes a 50-metre allowance. And I know MOD wants to have an input in terms of in terms of still your interests on micrositing, but we can't have that conversation today. So that's so I think that's where we're at. Bailey, perhaps I could come to you first in terms of why the 50. Oh, Mr. Barker, apologies, I missed you.
Thank you. Please forgive again my ignorance as a layman here, but on behalf of both Visit Moffat and Moffat and District Community Council, I would like to make the point regarding micrositing that we would like you to consider between the applicant and the council 3 specifics, if you would be so kind. One is that given the conversations we've had over the last week about visibility, that no micrositing adjustments should result in a movement either to the north or the west of the currently proposed location. So an absolute ban on north or west. That there should be no circumstances where any micrositing adjustments increases the visibility of any one given turbine. And lastly, there should be no micrositing adjustments where the height of the turbine is increased. So 3 parameters, not north or west, not to increase visibility, and not to increase the overall height above sea level of the turbines. Thank you very much.
Thanks, Mr. Barker. Well, I'll ask for the applicant's comments on that in a moment. The second point strikes me as potentially troublesome in terms of increasing visibility, because there would be a question of where and how could that be measured potentially. So subject to that doubt in my mind, I'll come to Ms. Bailey, please, in terms of that point around the sort of 50 metres versus 100 metres disagreement first.
Yes, thank you. So I think 50 metres is fairly established practice in terms of a micrositing allowance without local planning authority input. I think if it was to increase beyond 50 metres, then there is the prospect, certainly from the planning authority's point of view, that does more materially change the landscape and visual impacts that have been identified. And certainly from that perspective, we would be looking for it to be retained to 50 metres. I note from this, for example, the Sanker 2 decision, which was a fairly recent one, that is a consistent position there. And sorry, if you can just give me a minute to pull that up, because I'm thinking that I read something that might be a bit similar to the point that Mr. Barker was making. So, page 189. My page numbers are all over the place in this for some reason. Sorry.
It's fine.
Got it here, yeah. So yes, that condition says no wind turbines, access tracks, or ancillary structures constructed except in the positions indicated in the additional information, with the written approval of the ECO in a position up to 50 metres from the relevant positions, or with the written approval of the relevant planning authority in a position greater than 50 metres. So yes, I'm just, it's a slightly different scenario there, just in terms of the point that Mr. Barker was making, but I see that under part 4 of that condition, there's a more restrictive element just in terms of the proximity to individual residential properties. So there is obviously, precedent there in terms of setting something that is more restricted in terms of particular turbines. I would comment that I need to think just a little bit more about the point that Mr. Barker's making under part 1, and perhaps if we were looking at that, it might need to be with reference to specific turbines rather than across the board, across the scheme, because I don't think you would necessarily just describe it as adjacent to the north or to the west. On the second point about the visibility, yes, I agree with you there, sir. I think that would be difficult to be able to set in planning condition terms, in terms of being sufficiently precise and without requiring further input and a judgment as what that means. On number 3, micrositing where the height, and I appreciate the point that you're making, Mr. Barker, that that's not just height of the turbine itself, because there is obviously a separate condition which does restrict any increase in the height of the turbines beyond the height that's permitted for that turbine. The point that you're making is where that micrositing would, by way of the adjacent ground being at higher ground level, increase the overall height and visibility of that turbine. Again, I think we would need to look at that in a bit more detail to work out, are there particular turbines where that is a particular concern or issue. I don't think we could necessarily say today with any certainty what elements of the scheme that would encompass, but I do appreciate the concern that's being raised, and particularly, in relation to the visibility of the perimeter turbines and the visibility on surrounding communities.
Thanks, Ms. Bailey. Mr. Hardy or Mr. Campbell?
So in terms of residential amenity, which is often the reason for limiting micrositing, that is not a reason that's not in something that's in play at this on this scheme. I think given the size of the scheme and the size of the turbines, 100 metres we feel is proportionate, and therefore I think we would suggest respectfully that we stick with what we've got. Mr. Barker's suggestions are, I'm just picking up really on a point that Ms. Bailey made. It sounded as though that would be all turbines can't move north, and that clearly wouldn't work. I'm not sure whether it was that or whether it was actually the most northern. A sort of line is drawn at the northernmost turbine, as in nothing can advance beyond that line. As
I can see Mr. Barker nodding to that, Mr. Hardy.
Yeah, rather than no turbine being able to move north. Similar, and then points that Ms. Bayes just made about precision on height and so on. So I think given the scheme as it is, we would prefer to stick with what we've got. They are all subject, of course, to the ECOW approval. So you'll see that it isn't just carte blanche. There has to be the written approval of the ECOW. So that is under B. So 41B. Whether or not 100 meters is too much, we think it is we think it's appropriate, but that ultimately is a matter for you. So, and you've also you had your experience at Sanka. Council is suggesting 50 meters. That would be a matter of judgment, but we don't think that's justified here.
Okay, thank you. Ms. Bailey.
Thank you. Just to come back on that point about the ECOW approval, I mean, my understanding would be that the ECOW is predominantly looking at the impacts on, for example, moving turbines in relation to water courses or other sensitive habitats, whereas, of course, the concern that's being raised here is about the micrositing in terms of the landscape and visual impacts. So I don't think that would necessarily fall within the remit of what the ECOW would be looking at, whereas the planning authority would be looking at it from that point of view as well, which is why, and particularly given the scale of the turbines, I think that is why it is important that it's quite, it's not necessarily a greater degree of flexibility because the turbines are taller, because that does potentially result in further landscape and visual impacts that haven't been assessed. Just also on the point, just thinking about the point that Mr. Mark is making about the height of above sea level. I mean, I don't, obviously we would need to look at this in a lot more detail, but I would suggest a lesser micrositing allowance is probably going to have less impact in terms of height differential between the existing ground conditions, so that there's probably less possibility of the ground level being substantially higher. That's going to increase the visibility. So I think if we stick with the visibility, the allowance of 50 metres, that may well, hopefully to some degree, address Mr. Barker's concerns as well.
Thanks, Ms. Bailey. I think we can leave that there. I understand the points being made. I think if the opportunity presents itself when you're looking at conditions together again to produce a final schedule, if there's any further work that can be done on that point, that would be helpful. Thank you. Okay. So then on to, sorry. I might be missing just bear with me. So do we jump from, in this schedule, do we jump from 4 to 6 in this schedule? Is there a condition 5 that's gone awry somewhere? Because I've just spotted that as I'm turning the page. So sorry, I hadn't spotted that previously.
Sir, I think I had noticed that in a previous version that there was a slight misnumbering. So I don't think there is one missing. Fine. I'll let the applicant confirm if that's the case. But
yes, it is a numbering issue. There's not a missing condition.
That's fine. As long as it's just a missing number, that's all I need to know. Great. Yeah, sorry, I haven't spotted that until just then. Okay, so I've noted in condition 6, Mr. Milne, you said rather than the reference to Defence Geographic Systems, that should be Defence Geographic Centre, and that appears twice in this condition. To check with the applicant, you don't have any concerns with that? No, sir. No. Great. Mr. Milne, was there anything else to add on that condition?
No, that just hadn't been spotted in the earlier iterations of the schedule. That was the only point remaining from the MOD in respect of that condition.
Okay, thank you. Right. Okay. So then, in terms of condition 7, this isn't agreed. This is in relation to redundant turbines. Okay. So am I correct in kind of categorising the sort of disagreement as it's over the extent to which detail needs to be stipulated in the condition itself as to what the scheme should specify? Is that essentially it? Mr. Barker, I've seen your hand. I'll come to you in just a moment. Okay.
Yeah, if I can just go first
Yeah,
just to clarify that.
thank
Yeah,
you.
so yeah, I think that the principal difference is really in relation to part 1A, where so I think there's some misnumbering in the original condition of number 7 as well, because it goes 7B and C. So I'm talking in the third column under
Yes.
council comments. We've got the council suggested condition of 1A saying together with turbine foundations to a depth of 1 metre below ground level,
Yeah.
whereas the condition that's been suggested is to just for the turbines and infrastructure to be removed from the site and the ground restored. I've had a conversation with the case officer about this particular condition because I just wanted to understand their perspective in suggesting this as a draft condition. And he confirmed that he just considered that this was a more precise way of describing the type of information that they would be looking for from the applicant in terms of the information, and to ensure that it's that there's adequate removal of that of that foundation, and obviously the ability for the ground to be restored and to renaturalise. So that's really the purpose for the intent for asking that. Other than that, there's not really any particular difference between the two.
Thanks. So I suppose my question, by way of follow up, there would be whether it's conceivable that removing to a depth of less than 1 metre might be more desirable in certain circumstances, and whether the applicant's proposed condition offers that flexibility to say, oh, actually, maybe a metre isn't what we want to aim for whatever reason. That I can't identify now, but might be identified when you were to kind of survey that particular part of the site at that time. I don't know. Maybe I'm overthinking it, but.
I think that's a fair point, and perhaps it's perhaps worded to just more expressly say that they'll be looking for details of turbine foundations to be removed below ground level. And obviously, the purpose of the condition is to allow for a scheme to be provided to the planning authority for approval. So that would allow the applicant to explain the reasoning in terms of why they're looking at a particular depth.
Mr. Barker, sorry to keep you waiting.
That's no problem. Just you will recall from last week's sessions, there were a lot of concerns from the community about the presence of large amounts of concrete in the hills. So speaking on behalf of the community council, I would like to understand really why the condition is not being applied that suggests that when a turbine is redundant, the entirety of its foundations are not being removed and the ground subsequently made good. Because I would have anticipated that in all cases, at the point of redundancy of a turbine, either during the operation of the wind farm or at the end of its life, the entirety of the foundations is what should be being removed. And I'd be grateful if the applicant and the council could try and resolve that situation between them, because at the moment it's a compromise that I don't think the community would understand. Thank you.
Thanks, Mr. Barker.
Excuse me, Mr. Warner.
Mr. Clement.
I just want to support Mr. Barker's concerns. In total, total removal of the foundations, I feel, should be removed. That'll be some time away, but I think it's essential for the removal completely of the foundations to allow the natural world to regenerate. Thank you.
Thanks, Mr. McClellan. So I'll come to the applicant in just a second. My understanding of the condition as proposed by the applicant would allow for potentially the removal of the entire foundation or something less than 1 metre, so that full spectrum of whatever is appropriate on a turbine by turbine basis. Mr. Hardy or Mr. Campbell, would you like to add anything?
Yeah, I don't think we've much to add, sir. As you've said, I mean, our position is that the plan would have to be submitted by the applicant, would have to be approved by the council, and as worded, the applicant will obviously have to present a plan and justify the measures in that plan, and it does allow for the flexibility that was mentioned to accommodate different depths and so on.
In terms of the second part of the condition, the council's suggested condition would give longer for the implementation of the approved scheme. I'm just asking Ms. Bailey, is that a deliberate change from the proposed condition from the applicant?
I don't know the answer to that, if I'm honest. I as I say, this is taken from the committee report, and the council, the case officer confirmed to me that they'd gone through and done it on a case-by-case basis. So I'm not sure if there's a particular reason why they suggested 9 months.
Okay, that's fine. And that very last part, all to the satisfaction of the planning authority, I think it's caused reporters to squirm in the past. And so I'd just like your views on whether or not that's a sufficiently precise term, Ms. Bailey, and then Mr. Hardy or Mr. Campbell.
Well, I note first of all that both the suggested conditions have that wording.
They do.
Yes, yeah, it's not an area of difference between us. Yeah, Mr. Armstrong's just confirming it's the same in some other conditions, but I do appreciate it's maybe kind of going back to the discussion we had about reasonable and justifiable, etc. It's not necessarily completely precise, but I think the point is that it also needs to be undertaken to the satisfaction of the planning authority on a visit to the site post the turbine having been removed. So therefore, if you've got to implement the scheme, but if they come out and they had a look at it and thought, well, you hadn't actually undertaken all the measures, then it gives them some leverage in terms of going back to say that they need to do a bit more.
Okay. In the grand scheme of things, this is, I suppose, a more minor point. I wonder whether they're sort of fully implement the approved scheme within 9 months or something like that would be perhaps more precise. Then there's not that doubt about, I suppose, the planning authority taking a view that, oh, this isn't quite what we thought you meant, and not discharging the condition on that basis. So
I think that would help.
Mr. Hardy.
Respectfully, I think that would help. So the point is about implementation, isn't it, of the scheme? That's the metric. So it's not that you sort of have a scheme and then there's a freestanding decision about whether or not that's satisfactory from the council. So I think yeah, that would help.
Okay, I'll let you. I've got my notes on that. I'll let you let the applicant and council have that conversation offline as well in terms of that final schedule as well. That point would obviously apply to anywhere else it appears, so I won't repeat myself on that today. So in terms of condition 8, the environmental clerk of works isn't agreed. So I think the dispute's relating to the duration of the appointment, isn't it? So this is whether it's kind of a pre-commencement and then operational period appointment. Ms. Bailey, could I come to you first, please, in terms of the council's position on this?
Yes, so that's a correct summary in terms of the area of difference. So the the council suggested condition was to allow for the appointment of the ECO throughout the duration of the construction, the operational, and obviously the post restoration period. And the applicants noted that the ECO role doesn't remain once the wind farm is constructed and operational. But it's certainly understood that there are provisions, for example, in the bat protection plan or in the species protection plan, which may require some ecological input during the operational phase. Now, my view would be that given the condition would be effectively to agree the terms of an appointment of an ECO, I think it could be a situation where those terms could include for an ad hoc appointment during, or an appointment for a company to provide ad hoc ECO advice to the developer and to the planning authority during the operational period. It's not necessarily requiring them to be on site or undertaking specific monthly visits or anything like that, but just a kind of they're on a retainer sort of basis, if you like. Now, obviously, we would be looking at the scheme over a 40-year period, and I accept that's a long time frame to have that sort of appointment. But again, the terms could potentially allow for triggers for a review of what company is commissioned to undertake that role. So I do think it's possible to do that, and I do think it's as I say, it's important that there's still that advice available during the operational phase, and just to ensure that the ongoing commitments in the various protection plans are adhered to.
Thank you. Mr. Hardy or Mr. Campbell, would you like to respond?
I mean, it's probably not a huge difference. I mean, the applicant absolutely understands that if there are ongoing surveys or ecological obligations, those will have to be undertaken by an appropriate person. I think the particular issue is whether the ECO role, and obviously the costs associated with that, is necessary to carry on throughout the entire duration, the entire 40 years of the operational period. And our position is that the ECO, as is fairly standard with conditions, is appointed for the construction and any post-construction restoration works that are required. And then beyond that, it will be the applicant's obligation to separately undertake any ongoing ecological obligations, surveys, protection plans, and so on, with such a person as is appointed to undertake that work.
And are those ongoing obligations captured elsewhere in other conditions that are in front of us this morning?
I think the one that has been raised is the bat protection plan, which would have ongoing obligations.
Anyway, do you think that leaves other gaps beyond the bat protection plan where there are commitments for the operational period which would be at risk without Parker Works in place for that period?
Yeah, I mean,
in some capacity.
I think that the role of the ECO is also to as a bit of a a go-between between the applicant developer and the planning authority in terms of advising the council on any issues of non-compliance. And I guess it would need to be established that if that was being left to these other conditions, that there is still that mechanism for the planning authority to be able to suitably monitor and be aware of any issues of non-compliance that have been highlighted. So I think that's really the reason why the council would prefer the ECO still to be there in some form or other during the operational period.
Okay. I've understood your respective positions on that, so I will give consideration to it. Okay, so the planning monitoring officer condition 9 is agreed. Good. Condition 10. So it appears that when this was issued yesterday afternoon, the council hadn't seen part P of the condition, and the reference is added to a timetable in part P. Have you had an opportunity to look at that, Ms. Bailey?
I have, yes, and I've no further comments. I'm happy to accept that.
So that's agreed. Great. Okay. Thanks. Commissioner Evans agreed. That's construction hours. Programme of archaeological works agreed. Peak management plan agreed. Okay, so then habitat management plan. Now, I think the disagreement, correct me if I'm wrong, is limited to whether the membership of the habitat management group is actually stipulated in the condition. Is that the extent of the disagreement?
Yes, I think that's the remaining point to be discussed.
So I understand the applicant's kind of response to that as it's written down in this schedule. So the question that comes to mind is if the condition stipulates membership and those who have been stipulated in the condition aren't willing or able to be part of that habitat management group, is the applicant able to comply with the condition, and what would be the remedy? I suppose that's is that essentially your concern, Mr. Campbell?
Absolutely, sir. And I mean, we've certainly had experience in recent applications where Nature Scott, in particular, have declined to be members of habitat management groups, and in some situations have asked in draft conditions for their name to be removed as a member. So it is exactly that point that where it is actually prescribed that membership shall include a particular party. I mean, I suspect it's something that there's not a huge difference there. There is no objection should Nature Scott wish to be part of that group, and perhaps we could change to a lesser obligation that Nature Scott be invited to join the group or something along those lines.
Yeah, I think the council would be content with that. I mean, I think it is important that there is a reference to them, because they will obviously, be expected by the council to provide some input, and without any reference to them at all, then I think it gives the expectation that they wouldn't be expected. But yes, I do appreciate the point in terms of the requirement for them to be there if they refuse to do so. So I'd be happy with that form of wording to say invited.
Yeah, it strikes me as a neat way to deal with the potential risk. Okay, that's great. Then, in terms of condition 15, the bat protection plan is agreed. Condition 16, water quality and fish population monitoring is agreed. Good. A construction traffic management plan. Again, this was one where I think there was a late addition or amendment which the council hasn't yet confirmed agreement to, but it looks to be in line with what you requested. So that's part 1H. Ms. Bailey?
Yes, I had a look at that, and it's in line with what we'd asked for, so quite happy with that.
So condition 18, the abnormal load traffic management plan and the accommodation works. So in terms of the abnormal load traffic management plan, that's agreed. Then in terms of the abnormal load accommodation works, so on this one, it appears that the disagreement's over whether to include essentially a landscape mitigation scheme as part of the accommodation works. Is that correct, Mr. Campbell?
Yes, sir. And this may be a simple matter of definition, and what the council means by landscape mitigation scheme. I mean, I think it would be perfectly normal to include an obligation to restore working areas involved in any accommodation works, and indeed for restoration of any areas where accommodation works were subsequently not retained. So it is perhaps a definitional issue as to whether that is what the council means in terms of a scheme of landscape mitigation.
Ms. Bailey, are you aware of whether that's the council's kind of intention? Is it that sort of limited focus around restoration, or is it something potentially wider than that?
In honesty, I'm not aware if they were looking for anything wider. I would agree with what Mr. Campbell's saying, in that it would be localised around dealing with the disruption that's caused by off-site roadworks and abnormal route deliveries. So I'd be happy to, again, that might be something that if we're looking at some further detailed wording of conditions, we can come to some agreement there, just to be clear in terms of what the council's expectation is.
Yeah,
Thank you.
we'd be obviously happy to post some wording for the council to look at.
Great, thank you, Mr. Campbell. Yeah, it doesn't sound like there's a great deal between you on this point. I think it is a case of just clarifying it, isn't it? Okay, I'm happy to move on that basis then. The next condition is condition 19, compensatory planting. Okay, so in terms of the cross-reference to the outline habitat management and enhancement plan, I can consider that. That's fine. I did note the condition as drafted doesn't actually stipulate the area or volume of existing woodland to be compensated for. So I'd be guided on that point. Mr. Campbell, have you got is that you don't necessarily need to fill in the blank for me now, but is that a blank which could be
absolutely, and I will ask the applicant to confirm that, and we can confirm that hopefully later this morning. So
great, thank you. Okay, then condition 20 is the access management plan. Okay, so it seems to me that on this one, I suppose the substantive difference is in between the applicant and the council is whether the access management plan needs to address access enhancement specifically as a recognised aspect of the management plan, rather than it being management, which could be interpreted in different ways. Mr. Barker.
If I may, on behalf of both Visit Moffat and the Community Council, this is a very important issue, an extremely important issue. And the role of access, whether by visitors or the community, through the life of this scheme is critical to all of us for all sorts of reasons. And it impacts on tourism effects, and it impacts on the community. And in the comments as they are currently placed, I'm concerned that the phrases suitable public access and recreational enhancements are nowhere near, absolutely nowhere near, focused enough for the purposes of reassuring the community. And I'd just like to remind people this is called a community wind farm, but as yet there's no relationship between the community and the amenity, and I put amenity in inverted commas, that will be provided by the wind farm. So we have a gap in terms of understanding what public access means and what recreational enhancements means. And we both know all know from the conversations last week that we're keen to see, should you decide to approve and recommend this, that this wind farm does not cause harm to the economy. So in some ways, we face the challenge of how do we turn this from a potential significant negative impact on the landscape to somehow we convert it to a visitor and community asset. And I don't think the current feedback between council and the applicant goes far enough to describe a mechanism by which that will be achieved. I mentioned on behalf of Visit Moffat last week at the community hearing the potential imposition of an infrastructure levy to pay for economic regeneration should there be harm. There are also issues around how might one deploy funding and a budget from the developer to ensure that public access and recreational enhancements have a mechanism and a structure to understand their correctness. Now, I realise that in here there's a reference to proposals for public access and recreational enhancements should be put to and through the council in Dumfries and Galloway. I'm not sure that the community here would regard that as adequately suitable. We've already gone through the experience for the entirety of this wind farm of the legal position of Dumfries and Galloway Council being to refuse discussion and negotiation with the local community. And I think should we see a condition agreed that says Dumfries and Galloway will have some role in understanding and defining what public access or recreational enhancement means, that should be supported by full dialogue and interaction with appropriate local community representatives. So lots of concerns about the specific nature of what's being described here at the moment. Thank you.
Thanks, Mr. Barker. Yeah, so there's quite a bit in that. In terms of the, first of all, on the specific point around the condition 20 in terms of the access management plan, Mr. Hardy or Mr. Campbell, would you like to comment in terms of, I suppose, the intended scope of the condition and whether or not that's intended to be a enhancement plan or whether it's something else?
I think that the scope of this condition relates to access within the wind farm site and provides that the plan will firstly set out how that access will be managed during the construction and operation period and also identify opportunities for enhancement, recreational enhancement within the site, the upgrading of paths and so on. And that is, as we see it, the scope of the access management plan within the site, within the control of the applicant. I mean, it would appear from the council comment that they are looking for a much wider scope in terms of recreational enhancement, potentially beyond the wind farm site, and including areas that I think we would say are covered by other conditions. So matters such as biodiversity, compensatory tree planting, habitat enhancement. This condition is focused on access to and within the site, and that that is an appropriate scope for this condition.
Ms. Bailey, could I come to you, please?
Unmute button. Yeah, so I think when we looked at the first iteration of this condition, it does seem to be trying to cover two different aspects, and I do agree. I think these need to be separated out into two different issues. There's the management of access and the retention of public accessibility through the site, during the construction period and during the operational period to make sure that paths throughout the site are available to members of the public to use. But the first version of the condition also suggested the opportunities for recreational enhancements. And a note in the most recent version of the applicant's condition that's been removed. And as I say, in the meantime, obviously the council's made comments regarding this aspect about the recreational enhancement. So I think that needs to be separated out, and we could perhaps quite more easily deal with access management plan, but I agree that there's more discussion required on the recreational enhancements aspect. So just on the access management plan, firstly, I think there's one particular difference between the two conditions, in that the applicant's version says that the plan would set out how public access would be managed throughout the construction operation, including any temporary closures or diversions during the construction period. The council's recommended condition was that it should ensure that public access is retained in the vicinity of the community wind farm during construction and thereafter during operation. And I think it's the applicant's wording doesn't necessarily suggest that there would be access retained. I accept it says that there could be diversions, but it's just to make clear that they would be looking for access to be retained through the site during the construction period, albeit taking into account health and safety requirements and all these other aspects. So I think that's one issue.
On that, sorry, Ms. Bailey, just pause there just a moment. So on that particular point, does the submission of an access management plan give that kind of control to the planning authority to say, okay, we want to ensure that access over this core path or this particular route during the construction and operation of it? I mean, is that a matter that's within the gift of the council to kind of control anyway?
Yes, I'd agree with that. I think that's the lesser of the 2 points. The bigger issue is the recreational enhancements issue.
Okay, that's fine. Okay, I'll let you carry on that on the bigger of the 2 points, please.
Okay, so yeah, so I mean, going back to the committee report that was presented to members, and obviously we've had a lot of discussion on that over the last few days, both at the session yesterday and I'm aware it was discussed at the landscape and visual session. But it was certainly clear from the landscape officer's position that her recommendation not to object was subject to particular mitigation, and she did quite clearly identify in her recommendation that it would be subject to a condition about recreational and placemaking enhancements. So if I can just find that condition. So that is in the committee report. If you look at page 12 of the PDF, section 1.2, paragraph 1.2.1, she had a recommendation of mitigation by design, setting out that there were significant landscape and visual impacts, which she considered were addressed to some degree, but there were impacts that had not been addressed, particularly from the problematic turbines, except we've discussed all of this, so I'm not going into that in detail here. But she does say that provided that the recommended conditions are applied and enforced with compensatory mitigation put in place, she considered it might be deemed acceptable. And then in terms of her actual conditions, those are I lost the place, to be honest. That was just above there, where she's got 1.1.2, which is on page 11 of the PDF, requesting a condition for compensating mitigation in terms of providing benefits for habitat and wildlife, placemaking and recreation and landscape, focused on areas and communities where aspects of adverse impacts have not been fully addressed by the mitigation by design reviews. anticipated that these could relate to enhancing broader environmental benefits, addressing local landscape enhancements, recreational aspects, interpretation for natural and cultural heritage, and a forest plan for Estill Forest. So the interpretation of this is that is not clearly not necessarily limited to what is within the boundaries of the application site, but it was obviously a key component of her assessment that there would be potential and there would be a rationale for doing more. I do accept the point that the applicant's making that there are aspects of that that are covered under other conditions in terms of biodiversity enhancement. I think the remaining issue is really around those issues about the landscape and the recreational benefits and impact enhancements could be provided. Now, in terms of addressing this as a condition, the committee report did, the case officer did consider this, and he did put forward a condition in the draft report, which I had a look at, and you can see the comments that have been made in previous, in the council's comments, where I had reviewed this with him and considered that the terms of that in itself might not meet tests for a condition, but it still doesn't. So I think some further consideration is needed of the best way to address this in order to deal with the wider recreational and landscape impacts. Just on a particular point that Mr. Barker made, and apologies, Mr. Barker, I don't know the background in terms of discussions that you've had or dialogue that you've had with the council on this, but I'd maybe just flag up that there is also a later condition that we were going to discuss around a community liaison group, which was predominantly focused around the transport impacts, but from the council's perspective, I think they would see that as having a wider role, and perhaps that's something that we also want to consider in tandem with this issue.
Thanks, Ms. Bailey.
Mr. Warren,
Yeah, so Mr.
Warren, you have to put all of these issues into a context, because, you know, I mean, it's quite clear this is an operational industrial site for 40 years. So there will be considerable issues ongoing over that period of time. Thank you.
Thank you. Mr. Campbell and or Mr. Hardy, in terms of the sort of proposition of Ms. Bailey and Mr. Barker there, in terms of separating out, essentially, there's the kind of operational on-site, how do we manage access during the construction phase, how do we make sure that that continues, kind of nuts and bolts of it, and that separating out potentially of a kind of a more, I suppose, a benefits package in terms of kind of recreational enhancements. Has the applicant given thought to that as a condition, or do you have some other mechanism in mind where that might be accommodated, or is your position that that's not a necessary part of this of this consenting process?
If I don't know, I mean, I can perhaps start with that. Of course, if the consent is sought on the basis of the landscape effects, and if you were to just, the ministers were to find those acceptable, that is the consenting position. That having been said, that the applicant is very happy to consider these points. There are a number of topics, aren't there, at play? There is the sort of nuts and bolts access. There's continuing access on site. There is then access off site, and then there's the question about the more broad-based compensation, which the conversation has also taken in. So there's actually quite a number of topics, and I think that one answer probably isn't going to hit all of those in terms of lawfulness of whether you can do that, whether you can have a plan which provides for matters that are off site. I think we're going to just take on board what's been said and have a discussion. What I would say in terms of finance. Of course, the community benefits package, albeit that's not a material consideration, that's the sort of money that can go towards funding some of these initiatives, and that could work through community liaison in terms of what is going to be preferred. So that isn't a precise answer, and I think where we've got to, listening carefully to what's been said, is it's a little bit further thought that we'd like to put to that with the council.
Thanks, Mr. Hardy. Mr. Campbell, do you have anything to add to that?
Nothing to add, sir. No.
Thank you. Mr. Marker.
If I may just make one final comment.
Yes.
It's not the view of the community that community benefits should be used for economic reconstruction. And any references that I'm making on behalf of Visit Moffat to economic reconstruction and support for that financially have nothing to do with community benefits. The other point I'd like to make is that it's quite clear that however well-meaning and well-intended the management of the applicant are, at this point in time, individuals change, circumstances change, and companies are sold and assets are moved from one company to another. And I do not think it provides sufficient comfort for the community not to see some form of duty imposed as part of any planning approval. It's not adequate to simply rely on goodwill in these circumstances, much as goodwill is appreciated. And should you decide to approve, I hope the community and the developer will end up hand in glove to do the right things. But as I say, circumstances can change, and we would like to see that duty of care embedded into whatever happens in the final decision, if that is to be approval. Thank you.
Thanks, Mr. Barker. I mean, Mr. McClellan.
Yeah, I just want to kind of try and relate the goodwill aspect as a kind of incentive to accept the scheme. You know, it's a kind of hushing effect of objectors. But the point I really want to make is I have no objection to community funding, what it might or might not do, but I do object to the funding on the basis that the funding ends up on consumers' bills as a whole. So it just increases the costs to everyday consumers like myself, and I'm a retired person. Thank you.
Thanks, Mr. McClellan. Well, on the last point, in terms of the benefits fund, it's not a material consideration which I'll be taking into account, because it's essentially out with the planning system. That's an offer that's made by the applicant, albeit there is Scottish Government kind of guidance on what figures might or might not be expected. That's not something I'll be taking into any account in my reasoning.
Thank you, Mr. Warren, for clarification. Thank you so much.
No problem. I think we can perhaps pause there now. I think and move on in a moment. Just in terms of that kind of question around the enhancement of whatever form being kind of offered as kind of goodwill. I'm less interested in kind of goodwill offers and more interested in what's necessary to make the scheme acceptable overall. And if ministers are minded to approve it, whether or not that's in line with my recommendation, any conditions need to be lawful, and I need to be very careful with anything that's kind of proposed there. I'm sure Ms. Bailey and Mr. Hardy and Mr. Campbell are going to be very careful with any wording that's put forward, but I recognise that, and I welcome you kind of taking that forwards and thinking about how some kind of form of enhancement in terms of access and recreation could be kind of captured as well. So on that note, I'm happy to leave that with you, and if we need further exchanges on it, we can have that too. That's perhaps
Mr.
a good.
Mr. Warren, will you be authorising a comfort break at some point?
It's perfect timing, because that's literally what I was just about to do. So yeah, I think we're probably all ready for a comfort break. So So yeah, very, very well timed, Mr. McClymont. So it's 11:25 now. I'd say let's have 15 minutes as we did yesterday, so we've got a chance to get a drink and so on. So if we could be ready to restart at 11:40, please. So again, please don't leave the call, but just mute yourselves and turn your cameras off if you wish. Okay, I'll see you at 11:40. Thank you.
Mr. Warren, if you could advise Mr. Barker that his microphone is still on.
Thanks, Mr. McClimate. Mr. Barker's just muted his microphone. I think we were all getting coffees and things anyway, weren't we? So nothing to worry about. Okay, welcome back, everyone. Thank you. See my eye over the screen. Yeah, we've got everybody back. That's great. Okay, so we're on to condition 21, operational noise. Now, on this one, I'm not entirely clear on the extent of the kind of disagreement, or to what extent this is unresolved. So, Ms. Bailey, is this a question of wording, or is it a broader question of whether or not the noise limits specified in the table are the appropriate ones.
Thank you. Yes, so I think I don't think it's an issue that the limits specified aren't appropriate, but we have, obviously the council has gone back to its environmental health office just to check on the applicant's suggested condition. The environmental health officer's comments were that they preferred their condition, and also there must be reference to the guidance notes which are now attached to this schedule. And I don't think the current condition actually contains any reference to those, and that would obviously need to be incorporated. But in terms of obviously the sort of the wider wording of it, it's obviously a very technical condition which requires that specialist input, and without the environmental health officer confirming that they're content with the rest of the condition, then at this stage we just we're relying on the council's preferred condition as the one that they would seek to be applied.
In terms of the environmental health officer or department's input, I'm assuming that they've looked at the noise limits that have been proposed, and I'd have expected to have been told by this point if there was a concern over noise limits for any property. So I suppose I'm just looking for some reassurance on that point as far as you're able to provide it.
Yeah, they've not confirmed any concerns with it, but neither have they confirmed that they're accepting of the condition as it is worded either.
Okay.
So unfortunately, I'm not able to give you any more at this stage. And again, perhaps I appreciate there are a number of other conditions that we're discussing that need to be further reviewed. We will continue to press with the Environmental Health Office on that, just to make sure that we can get to an established position on that.
Okay. I'll give the applicant a chance in just a moment. So yeah, my understanding, the wording looks pretty standard to me in terms of what I've seen elsewhere, and I think it's the heads of planning model condition that's been used. So I'm hopeful that this is just something that needs that final nod from environmental health, just to reconfirm their position rather than open up a debate about noise. But I shall await your kind of advice on that point. Mr. Campbell or Mr. Hardy, is there anything you would like to add?
Nothing really to add. That's the standard model condition. The figures, actually derived figures, are taken from the additional information. Obviously, it's a matter for the council as to whether they consider them to be, correctly transposed. But they are the figures, and they, as far as we're concerned, are agreed. And then the guidance note, specifically, they are not incorporated into the condition, as you will see. They're there as effectively informative. The working of the condition doesn't rely on those. The limits are the limits, and they're the actually derived limits which are in the table. They're there to assist those people reading the condition who may not be of such a technical background. Okay. So it's not that we're not doing anything different. That model condition has been in circulation for about 15 years now.
Okay. I'm happy to leave that with the council to confirm, please. So then moving on to conditions 22 and okay, yeah. So 22 is agreed. So Mr. McClyman, you in your hearing statement, you essentially kind of highlighted the need for kind of decommissioning, restoration, financial guarantees, and so on. These three conditions are where that's addressed, just so you're clear on that. So 22, 23, and 24. 22 deals with decommissioning, restoration, and aftercare method statement. 23 is site decommissioning, restoration, and aftercare, and then 24 is the financial guarantee. But I'm going to pause at condition 23. Again, this is just a point to just to check with you, Ms. Bailey. Is the council satisfied with 1L that's been inserted?
One L, which was yes, that's fine.
Thank you. Mr. Barker.
I'm just seeking clarification, if I may, please. In section 22, there is reference to decommissioning and clearance of all structures above ground, but I seem to have missed any reference to removal of subsoil structures, in particular foundations. I just wondered whether or not it's normal not to reference foundations, or if there is a plan to leave the foundations in situ at the end of the life of the structures. Thank you.
Thanks, Mr. Barker. Well spotted. Mr. Campbell, are you able to advise, please?
That is standard wording for that condition, and the removal of any underground structures or the depth to which they would be removed would be something that would be proposed in that plan for the approval of the council.
So essentially the scope of that plan isn't specified, and it would be for the council to agree or otherwise, depending on the details of it. Is that correct, Mr. Campbell?
Indeed.
Mr. Marker.
Well, just briefly, for the benefit of any council members or representatives that are present or listening, to say it is the long-held belief on behalf of the community that the developer has told us that foundations will be removed, and it's a matter of some concern to see that this is now turning into a judgment by a third party. Thank you.
Thanks, Mr. Barker. Yeah, it's an interesting point, and I would almost take it as a given that some, if not all, foundations would be removed. I wonder whether it causes, whether it offers comfort without unnecessarily kind of restricting flexibility to make some reference to foundations, not necessarily to say they shall all be removed, but to just to ensure that plan does pick up on foundations specifically rather than just above ground works. I think, Mr. Hardy.
Well, yeah, I know you hear it lots of times about removal of bases, and I think it's an understandable concern. What I hear from both ecologists, from people involved in drainage, people involved in the other disciplines, is actually you can do more harm by taking out bases, and it's a similar thing with other types of development. So it's not to say no, it's not to say yes, it's to actually make sure that they are considered and to work with best practice at the time.
Okay, Mr. Barker, sorry, is your hand back up, or yeah? Thank you.
Merely to say, on behalf of the community, we would seek absolute confirmation of best practice and due diligence in an open manner if it came to any subsequent decisions about the extent of foundation removal. And I accept Mr. Hardy's point that there may be some debate about best practice given any particular foundation, but it has consistently been an issue of concern to the community, and we have consistently been given to understand that the concrete foundations would be removed at the end of the life. And I think there would be significant community concerns if we did not know that absolute best practice coming to decision making regarding them was in hand. Thank you.
If I just may make a comment, Mr. Warren.
Yes, thank you.
My concern would be, do you incorporate the motorway routes to the turbines as foundations? The roadworks are almost a very significant to accommodate. They have to be substantial foundations roadworks to accommodate the 80-ton cranes or whatever the weight of the crane is. So I would suggest that that's more important. These foundations cover a large ground area, and so are they incorporated in as regarded as foundations? Thank you.
Thank you, Mr. McLaren. There's some overlap there as well with it in terms of kind of the access management plan and what might be proposed as kind of permanent retention as well in terms of access. But Mr. Hardy, sorry, I did cut you off there.
Yeah, nothing really to add.
Okay, sorry.
Yeah.
Okay. Well, I think let's put that in the category for now, just to explore, if we can, whether we can sort of give that comfort in terms of the fact that foundations and other works need to be considered as part of that method statement, or that strategy.
Really appreciated, Mr. Wong. I really appreciate that. Thank you.
Thanks, Mr. Farn. Okay, so yes, that was 23 we've agreed.
I think there is a reference to it. May be that's what Mr. Barker was referring to. I think it's paragraph 2.28.2. So 2.28.2 of the additional information. I think that talks about removal of the upper section of the foundations. So I think it was at the point about community led, being led to understand that by the turbine bases are all going to be removed. I think that just requires a little bit of closer reading, but it doesn't take away from anything that I've said. Best practice is, has to be observed, and it will be.
Thanks, Mr. Hardy. Okay, yeah, that's a helpful reference. On to okay, so 24 is agreed in relation to financial guarantees. So 25 borrow pits. Okay, so there are two components to this. Okay, so this is in relation to the scheme of works. You'll need to talk me through this disagreement as to what the scope of it is. Is it the scope of A and E in this condition? I wasn't clear, so I don't. I'll come to Ms. Bailey first.
Sir, yes, it is. If you have a look at the council comments of the 29th of 11th, that highlights those two paragraphs as being the area where some revised wording is suggested. And this is really just around both to, again, be precise in terms of what the council's expectations will be for what should be included within the detailed working method statement, and also to ensure that the programme of restoration and aftercare includes that detailed landscape plan and programme, which I don't think was included for in the applicant's condition.
Mr. Campbell, is there anything you would like to say on this?
I think in relation to the programme of restoration and aftercare, I think that is included in the applicant's condition.
Is this in terms of the proposed condition, which is in blue, so that's the applicant's, isn't it? Yeah. So it's under E. It says a programme of restoration and aftercare, and then the council's subsequent comment to that would be a proposed amendment that says a programme of restoration and aftercare, including a detailed landscape plan and programme. So it's that including our detailed landscape plan and programme, which sounds like that's the outstanding disagreement.
Yeah, I mean, this may again be sort of wording, but I mean that perhaps be changed to details of the restoration and aftercare of the borrow pits, including an associated programme for the works, or something along those lines. I wonder would that satisfy the council? Again, it was that sort of reference to detailed landscape plan. Here's quite unusual wording.
I think it's just in relation to, again, be precise that they would be looking for as part of the restoration of the borrow pits, that is, that should include for landscaping, all those areas where that borrow pits and the associated workings have taken place. So it's just to be clear on that aspect, and also to include for, the timing of such planting, and I guess any sort of replacement planting that might need to be done if that doesn't take for whatever reason. So it's really just on those aspects. That's my understanding of the council's, and that's why it was included in the council's original suggested condition in the draft committee report. So I've really just gone through and just tried to make sure that where there was any remaining areas of dispute, and accepting that the applicants presented the conditions in a different way from the way that the conditions were presented in the draft committee report, that we've captured any of those outstanding aspects that the case officer had quite carefully gone through as they drafted the report.
Mr. Campbell.
Yeah, I mean, would I suggest this is another one? We will look at that wording. I don't sense that there is a substantial difference between us there, and it may be may well be a case where if we tweak the wording of that, we're both essentially saying the same thing in terms of what's to be done and when is it to be done, and forward that in the amended schedule.
Great, yeah, I'm reassured by what I've heard. It doesn't sound like there's much between you, so no, that's good. Yeah, I'm happy for that to be kind of carried forwards.
Yeah.
Okay.
And I think the other point was in relation to the potential for air overpressure or ground vibration disturbance to nearby buildings, and the applicant's position on that is that's essentially associated with residential potential impacts on residential buildings, and given the distance to the nearest residential building, that is not seen as an issue in this case.
I'm happy to take further advice on that with the case officer, just to confirm that position, just as we go through any subsequent discussions on the conditions.
Thank you. I'll move us on. That's helpful. So condition 26 is now agreed. The species protection plan. We've got the deer management plan under 27 agreed.
Sorry, sir, I've got the species protection plan as 25 and deer management as 26.
Bear with me.
No, I'm 26, and then deer management is 27, is what I got.
Yeah. So I'm looking, Miss Bailey. I'm looking at the version which was circulated. I think it was about 4:30 yesterday. And it's got blue and red and green annotations.
Yeah, yes, that's the same one that
Same
we've
one?
got, but on my version it says page 44, species protection plan and surveys, and it's got number 25 with it.
Oh,
That's curious.
mine's page 40, like yours. So mine's page 44 with 26 on it. Is that to do with tidying up on the? There was condition. Was it 5 that was missing?
Yes, it was.
Is that something to do with that?
Were there 2 versions of this issued yesterday?
I've only seen one. But
So the one we have certainly species protection plan and surveys is condition 25, and
okay.
deer management plan is 26. That was the one that was emailed to us yesterday afternoon by the applicant.
I don't think we're going to get to the bottom of that now. What I'm more concerned with is that we're all looking at the same wording. So I think when you take this offline to kind of make those final checks, can I just ask you to just double check that you've been looking at the same wording that I've been looking at today, and you've been looking at the same wording as each other on the conditions so far, that's going to be very important. I'm not concerned about the numbers in themselves. They'll need to be adjusted anyway. So, okay, so with that cautionary note in mind, so 26 is agreed, 27, the management plan agreed, and then, well, that brings us then to the end of the numbered ones. Oh no, we have another one picked up. So then we go into the unnumbered ones, which were the suggested conditions. So so after 27, okay, so then we had a floating roads proposed condition from the council, but through discussion, that's now been decided that that's not a required condition. So that's my understanding as to where we're at with that. So we're probably straying into kind of item 3 on the agenda. I'm comfortable with kind of some overlap there. We'll just take things as we find them, but I will give people an opportunity to raise any other matters, just so you're clear that you're not missing that opportunity now. So the breeding birds protection plan condition not required. The roads post construction work not required. Then I've got it numbered as 28, and that's roads extraordinary damage. The applicant's condition is agreed, so that would be added into the final schedule. And then it brings us on to the transport monitoring officer, which isn't agreed, and this is a condition that's sought by the council, kind of separate to the planning monitoring officer role. Ms. Bailey, could you say a little bit about that, and whether this has been something that's been established before, and if not, is it something that's particular to this case in some way?
Yep. So this is a condition that was again suggested in the draft conditions in the committee report. My understanding from the case officer is that in drafting up those conditions, he had taken into account other schemes. I'll be honest, I'm not aware if there's particular schemes where Dumfries and Galloway have applied this. I suspect they probably have suggested it as a recommended condition on other Section 36 applications where perhaps they've not objected. And yes, I mean, obviously the purpose of it is to just ensure that the planning authority and the roads authority are aware of any compliance issues in terms of the traffic management plan during the construction phase. And so I note the applicant's point that they consider that could be undertaken by the PMO, and the point that I'm just making is it's quite a different type of compliance that I wouldn't necessarily expect an individual who's undertaking a planning monitoring officer role to be able to comment with sufficient expertise on aspects that this condition is seeking.
Thank you. Mr. Campbell.
As said by Ms. Bailey there, the applicant's position is that it is unnecessary to have a separate transport monitoring officer, that can be encompassed within the planning monitoring officer role. They're both looking at conditions and adherence with those conditions. Equally, we wouldn't think that it would necessarily have to be an individual. It may be that it is some sort of entity that is appointed to that role, and it may in fact be different individuals within that entity that are looking at different aspects of the conditions, but nonetheless there is no need for a separate appointment.
So yeah, because I suppose that the key there is suitably qualified. Taking Ms. Bailey's point, that a planning monitoring officer might not be suitably qualified to deal with some of the transport aspects. I didn't dwell on the planning monitoring officer condition. Did that make clear that it might be a firm rather than an individual, or does it give that scope? I'm just flicking back to it myself. If you can remember which condition it was, that would be helpful.
It's condition 9.
Okay, thanks.
Yes, I mean, it refers in part 1 to company or other entity
Okay.
as being potential PMO.
Sorry, if I could just clarify that it does. It states that the PMO will be an appointment of an independent and suitably qualified person to assist the planning authority. And then the latter sentence about the company is in relation to a point that the applicant was making, that that same company could also provide the eco services. Now, as I say, I'd commented on that at the time and said that, you know, from the council's perspective, we've got no concern either way whether it's the same company, but they are distinct roles. The eco, the PMO, and a transport monitoring officer would be quite distinct roles, and each need to have suitably qualified persons. Those persons may be from the same company. I don't think the planning authority would have any particular difficulty with that, but they do need the individuals that would be undertaking the role would be suitably qualified. I have undertaken PMO roles myself for other schemes, and certainly, for example, Highland Council required for Corriglass that it was somebody that was RTPI chartered, and having undertaken it well before that for Dumfries and Galloway, again, it was a town planner that they were seeking in that role. So again, they are quite distinct roles for distinct purposes. So I'd have no difficulty with it being a company employed to do those things. And obviously speaking on behalf of the council, and I don't know what their position on that be, but I can't imagine they would have a difficulty with that as long as the purposes of the conditions specify that the roles are discrete and are undertaken by suitably qualified individuals within that. So yes, in terms of that planning monitoring officer condition, the ECOW condition and the transport monitoring officer condition, if there's going to be cross-reference to companies, we probably need to look at those 3 conditions together.
Thanks, Ms. Bailey. Mr. Campbell, it does. So looking at condition 9 in its final form, it does talk about person, but I recognise the wider company point. Have you got any comments on what Ms. Bailey's outlined?
Yes, I mean, I think the wider company point is really just to clarify person, in that it's person or can be person in the legal sense of could include an entity as opposed to an individual who's doing it. I think it's really a matter for you, sir. I mean, the applicant's position is that there is no need for a separate transport monitoring officer. Obviously, you've heard what Ms. Bailey says there, but the applicant's position remains that it is something that could be encompassed within the wider PMO role.
Thank you. I don't have a complete sense of how kind of onerous a task this kind of transport monitoring aspect would be, and whether or not that does significantly move away from a appointment of a planning monitoring officer. I don't know if you've got any views on that, Ms. Bailey, in terms of kind of how different it is and kind of how kind of extensive a piece of work that might be.
I think it would potentially. So, I mean, the role of the planning monitoring officer is really to ensure that the terms of the permission are being adhered to in terms of the wider conditions and also the environmental commitments. And obviously, there's a very significant degree of overlap between the PMO and the ECO in terms of PMO making sure that they understand from the ECO what's going on site and how any environmental commitments are being undertaken. I don't know who the PMO would necessarily be speaking to confirm and be able to satisfy for themselves that the transport management plan commitments are being adhered to, and to be able to report on that if, as I say, they're a chartered town planner and not a transport planner or a roads engineer. I do think they're quite distinct areas. So I would certainly suggest that it is retained as a separate condition. Perhaps again giving thought to the fact that there are differing positions between the council and the applicant on this issue, but also that we are committing to look at a number of these other conditions. Perhaps we look at a couple of options for you to consider, so that if you decide, if Scottish ministers decide that it's not necessary, then okay, or it's encompassed as part of the planning monitoring officer role. You've got a version of a condition that deals with it in that way. But if you agree that it does need to be a distinct role, then we've got two separate conditions. Perhaps that's a way forward to just try and deal with this.
Thank you. Yeah, I mean, that would be helpful. There are two questions for me. I think it's kind of if it's needed, and if it's needed, how should that be captured? I'm approaching it with some caution, just so you're aware, because I'm mindful that PMOs are not always accepted as kind of something that's kind of sufficiently justified against the circular tests. I don't want to go there here. I think there is a case to be made, certainly for them, and there is a case to be made for a transport monitoring officer. So I'm interested in seeing what that condition could look like. But yeah, it's with that. I just to be clear that I will be approaching it with some care in terms of whether or not that is appropriate. But very happy to look at options on it. Okay, so on condition 30. This is the community liaison group condition. It seems that certainly between the applicant and the council, it seems that the disagreement is essentially what the scope of that liaison group is, whether it's essentially possibly just related to construction, traffic, and abnormal roads. Because I see that's the link from the applicant's response, or whether there is a wider role in terms of liaison. But I just want to first of all check my understanding of the applicant's position.
Well, yes. Although I think what's been very clear over the last 10 days, and I think the spirit of the inquiry sessions has been quite notable in this aspect. The community in Moffat is strong, and also the commitment from the applicant to work with the community is strong. So I think on reflection, we would in principle be happy to look at a community liaison group. It's the sort of thing that you get. I dealt with it lots of times, either on WIN, but also on things like mineral schemes where you can have a liaison group. I'm not sure we would fully agree with the wording put forward by the council, but I suspect that that's a matter for discussion. It's rather than once you get over the point of saying, well, look, we can look at that. We can we might be able to firm up on the words. Whether or not that needs to be prior to commencement of development, whether or not that could be prior to construction of certain elements of this. I suspect the community is going to be most concerned with the construction process, and I think that whilst the community liaison group may then have a continued role, my experience is that first period is when it is most interested. If there can be a date which isn't prior to commencement of development, that I think would help. So long way short, we've moved on that, listening to what's been said, and we'll try and formulate some words with the council in due course. So I hope that's welcome, and I hope that Mr. Barker and the others on the call sense that we have listened and we're taking it seriously.
Thanks, Mr. Hardy. Mr. Barker.
I'd just like to make the point, Mr. Warren, that I accept and I'm grateful for the reaching out there from Mr. Hardy. I think we're dealing with two separate issues here, and I say this both on behalf of MDCC and Visit Moffat. There is indeed the need for some community liaison around the issues of disruption, which will take place over a number of years should this get built. So community liaison in that particular context is one specific set of issues to do with what's actually going to be happening on the ground. I've repeatedly stated a few times now, there is a separate issue regarding community liaison around economic impacts and around how some of the council's aspirations for recreational enhancement are implemented and deployed, as well as the need for funding for those things. And I would be really appreciative of understanding that they are two separate issues. I think we are keen to pursue both of them as lines of discussion. But I would like to stress they are two separate issues. And should the council in Dumfries and Galloway wish to be involved in fine-tuning some wording with the developer over the liaison group over the aspects of build and what takes place at that point, I would again emphasise the lack of liaison thus far between the council in Dumfries and the community here in Moffat. And I'd like to make sure any final wording that gets agreed does include the community representatives here in Moffat and not merely an extension of the executive system in Dumfries. So
I think, Mr. Barker, if it helps, Mr. Barker, absolutely. There are, and I hope in the little, in the words I gave, there was recognition of that. There is a flurry of interest, understandably, in the kind of nuts and bolts of construction. So what's happening when and all of that. But then there is a, there is a continuing role for, potential lines of communication on ongoing concerns or issues. So that is, and also the community initiatives and how that's done. I'm not sure that requires a separate body. So I think it's two elements, which is accepted, but a community liaison group seems to me, and the other safeguards that are included and the mechanisms that are included in the other conditions as well. It's not just the community liaison group. So yes, I think one body will do both.
Mr. Marker.
Appreciate the comments, Mr. Hardy. I suspect the issues of traffic disturbance and noise and where lorries are going, with all due respect, are actually very different to the promotion and marketing and positioning of a tourist town.
I agree.
The immediate concern is about disturbance and that community group. And I recognise that and understand that, and I appreciate you're happy to get involved in that. I need to keep re-stressing it's not one group. We're talking about different skills with different issues to address a completely different set of circumstances. And I'd like to keep reinforcing that to Mr. Warren. It's two issues, not one issue, and it will be two bodies, not one body. Thank you.
I don't think we're disagreeing, really, Mr. Barker. I think if it's, they're on some of the technical stuff. That is a matter for professionals and for the council, and therefore the feedback loops which are built into conditions all the way through these schedules. I think it's a matter for the council. So that is just standard practice. But there is also a part that the community has to play, an important part in expressing concerns, feeding back in relation to those same aspects, as well as the forward-looking things and the more positive things that you're talking about. So I am absolutely agreeing with you. There is a separation between kind of lay intervention and professional intervention from the council. My simple point is that I felt both they need to be separated out, but in terms of the community involvement, a community liaison group would do both. Now that's our position. I hope there's agreement. If not, then perhaps I've misunderstood, but that would be our position.
Thanks, Mr. Hardy. It sounds like you're close together on this point.
I think so.
So, okay. Well, I'm content for that to be taken offline and worked on. Yeah, I'm encouraged, Mr. Hardy, by that being taken forwards. Okay. That brings us to the end of the schedule. So, in terms of the agenda, I asked if there were any other matters which should be dealt with by condition but aren't appearing currently. So now's the opportunity from anybody to raise any matters that fall into that category if we haven't already discussed them. I'm conscious we picked up quite a few on the back end of the schedule there. No.
Mr. Warren, if there'll be a lot of financial issues over the years, and we don't have a crystal ball to look at, but what will happen if the financial elements of this proposal break down, and who ultimately will pay the bill?
Well, there's a financial guarantee condition that's proposed, which should give that safeguard. So in the event that the operator wasn't able to fulfil its duties, that guarantee would be in place for the planning authority to then pick up the baton, essentially.
Thank you. And only one other point is it's an industrial site that has an ongoing process, and there will be replacement components to be dealt with in environmental terms. Now, where will these components, is there conditions to ensure that they don't end up in, the blades, for example, don't end up in, waste disposal sites? Some countries like Denmark and Germany have banned disposing wind turbine blades into waste, existing waste tips.
Okay. Yeah, my understanding, that's a separate regulatory regime that isn't concerned with the sort of land use planning aspect of this. I don't know if Mr. Campbell or Mr. Hardy would like to comment on that.
Oh, that's true. But I, at the time, I suspect the decommissioning plans, as we see these coming forward, are likely to contain some aspects of that. So yes, split between the different regimes. But there is I think a well understood need for responsibility and from the industry going forward. Absolutely.
Thanks, Mr. Hardy. That's fair. Okay. Actually, unless there's anything else under item 3, so before we close the inquiry, so just in terms of the schedule that we've been referring to, and we've talked about updates to that, I'd just like to kind of think about timescales for that. I mean, it's not particularly pressing from my perspective, but equally, I don't want to let it drag or leave it open-ended. So
you don't want to lose the impetus either, do you? We've had the discussions,
exactly.
And they're actually really quite fine points. My view is you probably want to, I'd say by the end of next week, if we can do it by, let's use this discussion while it's all fresh to try and get it done by Friday next week.
And that's good for me if that works for everyone. But
as long as the council, I don't know.
Yeah, quite.
Mr.
Armstrong or Ms. Bailey.
I understand as a result of availability, it would really have to be next Thursday for the council to finally sort of sign off on this if it's going to be before Christmas. So could we make it next Thursday, and that perhaps gives us all a greater
is that for sort of final discussion, Mr. Is there somebody? Would it be possible to have discussion with somebody just to work out what needs doing, and then we can obviously come up with some ideas, and then even if that is then signed off next Thursday, I think it would be, if we leave it all till next Thursday to formulate new wording and get it signed off, that probably isn't going to happen.
Yeah,
I think if it's just a question of finessing certain sentences, then that could be done after that. But I think any sort of more meaty points have really got to be addressed by next Thursday from the perspective of.
No. Perhaps I didn't make myself clear. We'd like to get on with it. What I was meaning is there are going to be availability of resource, even if it's not the full team, somebody to be able to have a look at it, now, as in the next day or two, to set those wheels in motion, and then it gets signed off next Thursday. My concern was if we just leave finessing, finding where, and then sign off next Thursday, it wouldn't get done.
Sorry, to make it clear, yes, there's availability just now and over the next couple of days, but Thursday was going to be the cut-off line. Yes.
No, that's no. We want to get on with it. It was more the opposite. That's. I'm glad for that clarification. We will get on with it, and then next Thursday, absolutely can be a cut-off.
Okay, that's great. Well, that's the 19th of December, so I'll expect something on the 19th or 20th. Okay, that's helpful. Thank you. Good. Okay. In which case, that brings us to the end of the agenda. I don't have any further questions or matters to raise now. So I just want to thank you all for your input. Oh, sorry, Mr. Milne. Apologies.
Yes, just thank you, sir. Just while we're all here to, and I don't know if you were going to touch on this in terms of outline of next steps, but just to ask what the current thinking is around fixing further procedure in relation to the Eskdale-Muir issue. The MOD asked the applicant recently for an update in terms of the investigative works, the experimental borehole, which they have drilled, and measurements that they're taking, because the MOD remains concerned not to have further procedure fixed in relation to its objection until the data from the experimental borehole has been made available and as the MOD has been given an opportunity to consider it. Otherwise, the procedure gets ahead of the parties' understanding of what the experimental procedures have disclosed.
Thanks. Yeah, thanks, Mr. Mill. Yeah, I was going to outline that, and that's a helpful link. So my intention is to schedule a meeting to discuss if and how the matter of Eskdale-Muir seismic array can be addressed through this inquiry process. So that obviously principally concerns the applicant and the MOD. And ahead of that, I wasn't intending to ask for an update for my own benefit from both parties. So I'm more informed on the current situation. I don't know if now is appropriate to ask for kind of any comment, Mr. Hardy. I don't know if you're able to comment on that.
Yes, I mean, I am, although I suspect that something in writing probably, in the new year is going to be helpful. But just to give you an overview, I think that's what Mr. Milne is, where his comments lead. So the borehole, I mean, people will be aware of what is posed. So the borehole has been drilled down to a depth of 200 meters. I think it's 197 to be precise, but deep into the ground. The casing has now been fitted. The sensor is going to be fitted next week in relation to in combination with the communications set up for data collection. There has been lots of discussion with the MOD, so Mr. Milne's client has been kept fully informed, and I'm pleased to say, based on previous experience, the degree of the engagement from the MOD is high, and that is very much to be welcomed. They're very interested in what's going on. They have undertaken what is called a huddle test. I had to look that up. A huddle test is where in seismology sensors are put close together to see whether or not they are calibrated in the same way. So AWE is undertaken a huddle test, which is in Berkshire apparently. So the sensors are calibrated. The good news is that MOD are happy that the sensors are going to be reading out in the same way. So they're going to go down the hole. We are going to start getting data next week, and there is the protocol for data sharing with the MOD is all going on. So positive message. We'll wait and see what the data has to say, and if there's going to be a further PEM at the end of January, then we will be able to set out procedure thereafter. But from where we are, standing, what was promised, data is going to be forthcoming. That is going to be shared. We are very hopeful about the outcome, and as I say, I'm thankful to the MOD for the engagement that they have shown. So I hope that's an overview. It's it's as positive as far as it can be with data. When the data starts coming through, we'll know more.
Okay, thanks, Mr. Hardy. In terms of the time period, in terms of how long is data collection intended to kind of be carried out for?
I think it's an interesting question, isn't it? Because I mean, from us, it's really a question actually for the MOD, because the whole point of this is to satisfy the MOD, and what we don't want to do is have too short a period where the MOD think, well, actually that's not enough to form conclusions. So we've thought 3 months in discussion. That is a minimum. So 3 months from next week. So that'll take us to December, to January, February, sort of March, sometime like that. But we will have a good indication by the time of the PEM, if that's in the last week in January, of where we're heading. So a 3-month period is what the MOD and the client, and our clients have considered.
Yeah, thanks, Mr. Hardy. Mr. Milne, is there anything you would like to add or comment on?
Well, that's all fair in terms of what Mr. Hardy has said. There has been good cooperation and liaison between the parties. My concern was more about there has been a delay in the, as I understand it, the commencement of the extraction of data. And as Mr. Hardy has said, the proposal has been for 3 months of data to be collected, and that starts next week, which I think is later than was originally anticipated. Where the MOD does not want to end up is the pre-examination meeting at the end of January, where further procedure is fixed for ultimately leading to an inquiry session with deadlines, as usual, for evidence to be submitted, when the data has not yet been fully gathered and parties have been given an opportunity to consider that data. Now, I don't know if a brief period in terms of extracting the data will be sufficient for views to be formed. We just know that parties are anticipating that 3 months of data will be collected. Now, it may be that what is required at some point in the new year is a discussion. Parties commit to writing what their respective positions are regarding further procedure, and whether it would be premature to proceed to a pre-examination meeting at the end of January, or appropriate to proceed to a pre-examination meeting at the end of January.
Okay, yeah, that's helpful.
Yeah.
Sorry, yeah, Mr. Hardy.
No, just entirely happy, with that, and I absolutely agree. There's no point having inquiry sessions set if, in fact, you just need a little bit more time. We are absolutely heading in the right direction. So whether or not we have a CMC, which is a sort of an advanced base camp in hopeful expectation of what will come. I mean, you've got enough data to make to see where that's going, or whether or not you are better off holding back for a few more weeks in order to get that data and then have a more firmed up position at CMC. I think that is a matter, probably, Mr. Milne, we hear what you say. So maybe a written exchange of positions in writing, sort of in third week in January, something like that. That might just have some data by then, and that will give an indication.
Yeah, I'll give thought to that. It sounds more attractive than having a premature PEM,
exactly.
which takes us nowhere.
Yeah.
I'm still, as you know, I'll be very careful with my wording to date in terms of if and how this can be kind of captured through this inquiry process, and that's still very much the case in terms of my thinking on it. With that in mind. Yeah, let me come. What I'll do is I'll write to the applicant and MOD and request a written update. I'll look at dates. Third week of January sounds kind of reasonable to me, but I'll just think about that kind of forward timetable as well. Okay.
Thank
you. Does anybody have any other questions or anything that they would wish to raise before I close this inquiry session? No, okay, in which case, as I say, thank you to all. Yeah, it's been constructive and I found it very helpful over the course of the last week and a half. And I close the inquiry. Many thanks again for your input. Thank you.
Thank you very much, sir. Thank you.
Thank you.
Thank you.